We're here today to talk about urban renewal, and by urban renewal we mean urban renewal under the Strata Schemes Development Act, which has recently been enacted. I'm here to discuss it with Michael Tees. Now, Michael Tees is a deeply experienced strata lawyer. He's got over 30 years experience in strata and property matters. He's lectured on aspects of strata and property law at Charles Sturt University and presented a television program on aspects of property and strata law. My name is Tom Davey. I'm a barrister. I've got experience in these matters. I've done a lot of strata law and building property development related law over the years. But I'll start by asking Michael, if I may. Michael, how would you define an urban renewal procedure?
Tom, an urban renewal procedure in the context of our strata laws is now available to us under amendments to the Strata Schemes Freehold Development Act. And it involves a proposal being put for the consideration of a group of owners. There's two types of renewal that's possible. There's a collective sale and there's a redevelopment. A collective sale is the sale of the property in one line to a single purchaser, and a redevelopment scheme is one where the owners get together and undertake a redevelopment. They may or may not participate in ownership of the end product. So those mechanisms are now available to people in strata title property, and we're just starting to see the beginnings of people availing themselves of that property scheme.
I think previously, in order to carry out redevelopments like this, unanimity was required amongst the lot owners. Is that correct?
Indeed, yes, there was a requirement for unanimity, as well as the support then of bankers and tenants and all sorts of people that have stakes and interests in property. So very, very complex and rarely done as a consequence.
Now, I understand you've been involved in proposals to amend the strata schemes legislation to enable something less than unanimous consent for a redevelopment or a collective sale of a strata. Can you tell us something about how this legislation came to pass?
Yeah, Tom, this happened in the late 90s. The Carr government, Bob Carr, was interested in what to do with the units that had already been built. By that time, units in Sydney were 50, 60 years old, and some of them were in pretty poor condition. There was also a lot of new buildings going up, some of which wasn't terrific, and the Carr government was very interested in what to do when these properties reached their use-by date. And so they commissioned, through the Urban Renewal Authority, they commissioned a study, and Philippa Russell, a colleague of mine, and I were lucky enough to win that commission, and we wrote a paper in 2000 looking at how this had happened around the world. There was very little being done. We looked particularly to the United States, and also to Singapore, which was quite advanced in those times about what to do with this. And we came up with the concept of strata renewal, which is largely, as it has developed over the years, it took something like 17 years to become law, but that I think says more about Australian politics than it does about law reform.
Thank you, Michael. Going on to the actual procedure itself, Victor Dominello in the first reading speech talked about an opt-in when the procedure is to be kicked off. How is typically the procedure commenced and required to be commenced?
The procedure is commenced by somebody putting a strata renewal proposal. That person may be a lot owner, it may be a developer, it may be an authority, but someone puts a proposal to the owners' corporation that something should happen. That might either be a sale or a redevelopment. And when it comes to redevelopment, that may or may not include the owners. So a proposal is put, and that starts a process that is then set out in the legislation.
This is a difficult question, Michael, but perhaps you could summarise as best you can the strata renewal process. I know it's very detailed.
Yeah, I think when I last looked at it, there's 21 different steps, but broadly and conceptually, they come down to this. It starts with a proposal. If there's interest from the owners, there's a strata renewal committee elected, and there's a process there for making sure that people hold the appropriate relationships and make disclosure about their interests. The Strata Renewal Committee is formed. It then takes the proposal and turns it into a plan. and that may involve the help of a developer or a promoter or funders. Once the plan is developed, that is then put to the owners' corporation. There must be a special resolution to adopt the plan. And then if that happens, individual owners are asked to give their support through support notices, and there's a requirement for 75% of owners by number to support the plan. Once that happens, it's off to court, and the court then looks at the proposal and makes sure that all of the technical requirements have been followed and that proper process and due diligence and good faith has been exercised in the formulation of the plan, and will then give effect to the plan by making orders of the court.
And I think there are very strict rules as to notice provisions in the process.
Yeah, it's quite technical. I think, and we're starting to see in the first cases that are coming through the courts, there is a very heavy burden on the proposer to follow the process and to follow the process correctly by giving clear notices and by giving them within the time frame specified within the Act. It seems to me that a failure anywhere along the line can be catastrophic for the plan. And so a great deal of caution is needed, and the support of a good strata manager is going to be essential to make sure that this process is done correctly.
On my reading of the legislation, the central document, the key document to this whole process is a document which is entitled the Strata Renewal Plan. So my question is this: what is the Strata Renewal Plan and what must it contain?
So the Strata Renewal Plan is the second of the important documents. It starts with a proposal. The proposal becomes a plan. The plan I would describe as a mini prospectus, or in more modern financial services terms, a mini product disclosure statement.
Yes.
It's a statement that starts with a position of intent. What is the plan? What is the broad concepts that the proponent is thinking of, and then delves into the detail about how people are going to be treated, time frames, how people are going to be paid, and I guess most importantly, what is the price that people are going to get, and how is that going to be split between the owners. All of those sorts of details and much more is set out in a plan. There are some minimum requirements that the legislation sets out, but there's also a catch-all where the Strata Renewal Committee should disclose anything else that they think might be relevant. And I think as we see these plans develop, they will go from a bare bones formula to a more descriptive formula that sets out the risks and the returns that might come with the proposition.
Okay, thank you. Just on the Strata Renewal Plan, and the proposal draw a distinction between a collective sale and a redevelopment. You've referred to that earlier. But could you flesh out a little bit what exactly a collective sale and a redevelopment are and how they're distinguished?
Yeah. Under the concept of a collective sale, the owners would be brought together under a Strata Renewal Plan to each sell out to a single purchaser. Now that purchaser may be identified in the plan, or it may be that there's a process to market the building as one and to find a purchaser. But in any event, the outcome of a collective sale is all of the strata owners convey their title to a single owner, and that single owner would then take control of the owner's corporation and the common property. So then, having, if you like, wrapped the building back up into one title, is free then to do with it what they will. They might knock it down, they might refurbish, they may extend. But under a collective sale, it's just quite a simple, well, it's not simple, it's complex, but it's a process of unstrata titling the property.
So the strata scheme comes to an end?
The strata scheme comes to an end. Well, not necessarily. What happens is there's a conveyance of each lot to one proprietor. The strata scheme may continue to exist with all of the lots being held by one owner, or the plan may provide for the strata scheme to be terminated. I think there's a degree of flexibility there. But in any event, the owners exit the property by making a sale for a particular price and having agreed on how that price will be distributed amongst themselves. The redevelopment scheme is a little different, and there is far more flexibility with a redevelopment scheme. A redevelopment scheme might involve a developer as a partner of the owners' corporation, and it could be that this happens in a circumstance where there is a greater yield to be obtained by undertaking some additions to a building or to a scheme. Or it might be that they decide to redevelop the apartment in completely different configurations. And this might happen where one-bedroom units fall out of favour and people want bigger units, for example. So there's a degree of creativity and flexibility in a redevelopment proposal that is all designed to get a premium for the owners. Nobody's going to bother to do this unless there's a prize, and that prize is going to be a premium above the price that they would otherwise get if they sold their apartment.
Okay. In practice, do you think there'll be more collective sales or redevelopments?
Look, I think there's going to be both, but I don't think they will involve developers as much as perhaps we might have thought originally. I don't think developers are going to have the patience to deal with strata entities. These processes are complex. The behavioural science of a strata entity is a discipline in its own right, and quite fascinating things happen when a group of people get together and try to make decisions about collectively owned property. And I think developers will find that very frustrating. Developers, by their nature, are people that like to get on with the job, make it happen fast, exit and get out. This is going to be a process which requires patience and a little nuance in the way in which people are managed. So I think what we'll start to see is owners' corporations going to property professionals and undertaking this process themselves for their own benefit.
Oh, I see. That brings us on to the Strata Renewal Committee. Now, the Strata Renewal Committee is charged, as you've explained earlier, with coming up with a Strata Renewal plan. If you could tell us something more about the function and operation of the Strata Renewal Committee, and one thing that I'm interested in is this. The legislation seems to envisage that the Strata Renewal Committee will actually develop the plan, whereas in practice, I strongly suspect their role will be confined to accepting or agreeing with a plan put up by somebody else. But I can understand that opinions may differ on that. What's your view?
Look, I've seen both happen. I'm in cases against you at the moment where we know that a developer has been involved and there's been a plan put and funded by the developer, and the legislation contemplates that might happen.
It does.
So long as there's a disclosure about that. I'm in another case which is operating outside of the Strata Renewal legislation, where unanimity has been reached over a series of years. And in that particular case, the plan has very much come from within and has been developed by a committee using consultants and in the same way in which a developer would use consultants to formulate a plan that came in some entrepreneurial moment to the developer. So I think it can happen either way, but however it happens, it requires a very strong personality to drive the process. And I think it also requires a trigger, and that trigger might be a local area rezoning. It might be a fire and safety order slapped on a building because it hasn't been properly looked after.
Yes.
There's got to be some impetus that causes people to awake from their strata title slumber, where people sort of just get on with owning property, I suppose, and don't care much about the collective entity. And then something happens, whether it's a rezoning or a travesty, a fire, a municipal council deciding that something's not right, that causes people to think, well, is it really worthwhile us maintaining the property in this form, or should we try and do something more interesting to improve our interests?
So the primary way in which the legislation is supposed to benefit strata owners is if, in perhaps two circumstances. One, if the block of units is like one of those very old cars, which it's more expensive to maintain than replace.
Yeah.
And secondly, when for some reason there's unrealised value in the strata, for example, there's been a rezoning or a change of use.
Yeah.
Would that be correct?
There was an interesting political shift
Yes.
over 20 years on that front as well. I think the concept, as I said, started because the government of the day didn't seem to be particularly happy with the style of development that was happening and occurring. But by the time that it got to becoming law, and the second reading speech of the minister seems to focus more on the use of the process because the building has reached its use-by date. It's interesting to see how this has happened in Singapore, where land is precious. And there, very much the process has been used opportunistically by people who realise that they're sitting on land that is more precious and more valuable if it was to be sold as one title to a single user. And so our legislation, I think, in New South Wales, when it was passed, was very consumer orientated, very designed to protect the vulnerable, for fear that literally people would be turfed out against their will from their property because it was decrepit. I think we'll see the legislation be used by developers and people within a scheme who realise that they're sitting on a premium.
Yes.
And I don't know that that was intended in 2016 when this became law.
But just to be clear, the legislation will apply in a fairly narrow range of circumstances. It's not required when there's unanimity.
Correct.
And it won't be of any use if the support is less than that stipulated in the legislation.
That's right, yeah. And so I think another aspect of this which will be interesting for our viewers is that this legislation may well become a threat to a dissenting owner, which forces the dissenting owner out of a building and leaves people in a position where they don't have to use the process.
Well, I must say my experience has been that the legislation can put dissenting owners in a very, very powerful position.
Indeed.
To drive a bargain.
Indeed. I think there's been an overkill, if I might say so, and it's no surprise here that I so far haven't acted for any dissenting owners, and you have, but it's, in terms of acting for owners' corporations and the majority who want to get on with the redevelopment, there is a very, very heavy bias towards protecting the interests of the dissentients, which of course can be exploited. I think there are two types of dissenting owners that we're starting to see emerge. The first is the dissentient, who is a person who's emotionally attached to a property and doesn't want to sell. The other type of dissenting owner that we're starting to see emerge is a developer who's taken, a competing developer who's taken a strategic position in a building because they see an opportunity emerging down the line, and are using the process for their own rapacious needs.
As someone who's active for dissenting owners, there are also people that genuinely think that the deal being offered is an undervalue, and I've seen that as well.
Yeah, yeah. So the process is there with a lot of checks and balances to make sure that what happens is firstly supported by a supermajority, secondly has been a fair and transparent process, and I guess thirdly signed off by the court.
Is it possible that the position of the dissenting owners will become less strong as people become more experienced in running these sort of cases and receive more experienced advice, and there won't be any holes or difficulties to exploit in the way the application has been prepared?
The experiences in British Columbia and Singapore would say otherwise.
I see.
In Singapore, there's been more than 10 years now of litigation, and that will be good news for all of our viewers. There's been more than 10 years of litigation about different elements of the process. And some of those cases have been focused on process, and other aspects of the case, which we haven't talked about yet, focuses on the need for the court to be satisfied that the plan has been put together with good faith. And the good faith requirements, I think, provide quite a degree of scope for a dissenting owner to allege that that hasn't occurred.
The support required for the renewal procedure to be enforced is 75% by unit entitlement and by lot. And I think I'm correct in saying it's 75% by unit entitlement if the owners committee decides that they wish to go ahead with the Strata renewal plan that's been devised by the Strata renewal committee, and then it's 75% by lot, which is a different thing when the ballot takes place, which is required to take place by the legislation. That's correct, isn't
That's right. So there's two hurdles there.
And after that, it goes to the Land and Environment Court, which is, I think, where the barristers come in, isn't it?
Well, that's right. Well, Tom, you and I have been on the opposite side of the bar table. So let's talk a bit for a moment about the litigation that may emerge out of this process. And of course, it might be that the litigation is quite perfunctory and that it's a ticking of the box situation, but it also could be hotly contested. What are some of the issues that you can see emerging from the bar who are advising people about how they might protect their interests?
Well, the requirements for the Land and Environment Court to approve a strata renewal plan and give effect to it are onerous. The Land and Environment Court, which is the court that hears these matters, must not approve the strata renewal plan or make an order giving effect to it unless it's satisfied as to a number of steps. Firstly, it will analyse the relationship between the lot owners and the purchaser or developer, that is to say, the proposed person in the case of a collective sale who will buy the units, or the person or the developer who has been or often is the guiding force behind the proposed development and may well have put the proposal in the first place. So they'll look at the relationship between the purchaser or developer and the lot owners, and they'll ask this question: is there any reason to think that this relationship has prevented the plan from being prepared in good faith?
Can I stop you there?
Yes, of course.
What type of relationships do you think might breach the good faith requirement?
Well, that's a very good question. Traditionally, when developers were seeking to redevelop a lot, before this legislation was introduced, they would enter into put and call options with lot owners, and quite often the put and call option will be coupled with a power of attorney, so that in fact, for the purposes of redeveloping the lot, the developer could stand in the lot owner's shoes. Now, where that happens, and depending upon the terms of the powers of attorney and depending on the terms of the put and call option, I think that would raise a serious question as to how the relationship might have affected the deliberations of the lot owners.
It raises the issue, doesn't it, that is rather curious about all of this, that an owners' corporation as a separate legal entity has a statutory purpose, and that is to manage the scheme.
Yes.
I guess the people that are elected to the Strata Renewal Committee are going to be in a position where they not only have to look after their own interests, but they've also got to have interests or be aware of and respect the interests of the dissentients as well.
Well, yes, but they may not necessarily be lot owners themselves.
That's right.
They have to disclose any conflicts of interests, but that doesn't actually prevent them from staying on the committee.
That's right. So going back to your put and call, so I guess the purpose of the put and call is for a developer to hold people to a bargain,
yes,
while they exercise these rights and deal with the dissentients. Does disclosure of the put and call cure any conflicts or issues about good faith that may otherwise trouble the court?
The good faith issue, I think, comes up primarily with powers of attorney and such like. The put and call option may also have an effect upon the way the court looks at the valuation issues, which they also have to consider. Just moving on from there, the courts have to be satisfied, of course, that the steps taken in preparing the plan and obtaining the required level of support have been done in accordance with the Act, and that all notices have been issued in accordance with the Act. That raises, to my mind, an issue which the court will have to decide, which is whether trivial or insignificant non-compliances will invalidate the scheme. It seems to me, on a literal reading of the Act, that they will, which puts a lot of pressure, I think, on solicitors acting for the Owners' Corporation, who will have to advise the Owners' Corporation whether all the steps, which may well have been taken with the advice of other lawyers, have been complied with.
And indeed Strata managers in this case as well. Just on that point, a dissenting owner, I guess, is entitled to put the proponent to proof on those issues. Just outline for us the rights that a dissenting owner has in the process, and who pays their costs, for example.
A dissenting owner has a right to file with the court, once an application has been made, objections, which should identify the various Section 182, which is the part of the legislation which refers to the task the court has to carry out. It should do this by reference to the issues which the court has to address. And it has a right to file a statement of objections and be joined to the proceedings and appear at the proceedings and call evidence and make submissions.
So that's an expensive process. I mean, we're talking about litigation in the Land and Environment Court.
And in the normal course, as you alluded to earlier, their legal costs will in fact be paid for by the Owners' Corporation.
Yeah. So the Owners' Corporation has a statutory duty on the one hand to advance the plan once a certain level of support is reached, but also has to pay for the costs of those that argue against the plan.
That's right.
So that, as you say, gives the dissenting owner a great deal of power. What about the bona fides of the dissenting owner? Are there any obligations, as you understand the legislation, for a dissenting owner to act with good faith in the same way that there is for those that are putting the plan together?
There's nothing in the Strata Schemes Development Act which requires objecting owners to act in good faith. Of course, they're subject to normal requirements for litigants not to abuse the processes of the court.
So their costs are likely to be paid by the proponent?
Well, that's an interesting point you make. I suppose if it could be shown by the Owners' Corporation that the dissenting owners were not acting in good faith, that there may be an argument as to cost. But it's difficult to see what not acting in good faith is. It's perfectly legitimate of a dissenting owner simply to want more money. That's not also, acting in bad faith.
And I guess it's also in those cases that we're starting to see where there are developers acquiring interest in buildings that are in particularly interesting rezoning areas, or areas to be rezoned, so that they are opportunistically acquiring these properties. It's legitimate for them. It's part of their legitimate business to make profit from taking interest in land. There's nothing necessarily of bad faith in them taking that position and using their property for their own purposes.
Nothing at all. And of course, if the majority decide that they don't want to proceed with the redevelopment or collective sale, then they would have killed off the goose that would lay the golden egg which the developer was looking forward to. So it's always a balancing act.
So far we've talked about process and the need for people to be compliant with the process.
There's good faith, there's process, but there's also the valuation issues.
Yes, I wanted to get you to the valuation issue because it seems to me that that's the focus of most people at the outset of the process. Tell me what standards have to be met in terms of valuation for a court to order that one of these plans be put into effect?
Well, I think this is going to be a very, very difficult task for the courts to be satisfied about. They have to be satisfied. It varies slightly from collective sale to redevelopment. But with a collective sale, they have to be satisfied that the proceeds of the sale, as distributed to the lot owners, or if the proceeds, the sale price hasn't been agreed on, the minimum reserve price or the way in which it's going to be calculated, is more than what is being termed the compensation value of the lot. That's in the case of a redevelopment. And the idea of the compensation value is it's a floor beneath which the remuneration envisaged by the scheme should not fall. With the redevelopment option, which you referred to earlier, it's a similar process. The court has to be satisfied that the amount received by the dissenting owners, the amount to be paid to the dissenting owners under the redevelopment scheme, bearing in mind that the supporting owners may not actually receive money, they may receive payment, as it were, in kind in the form of ownership of a redeveloped lot, but the amount received by the dissenting owners, again, must not be less than what's termed the compensation value of the lot.
So we've got compensation value, we've also got market value.
The market value is a concept introduced by in the Strata Renewal plan. There are various valuations that have to be done in the course of this. The Strata Renewal plan has to identify the market value of the lot, the whole parcel. The proceeds of sale, in a collective sale, is something that is planned to be distributed to the lot owners on the basis of unit entitlement. Now that will only be known after the court has made an order.
So when a valuer comes to value a property for the purposes of a collective sale, a solicitor might be engaged to assist the owner's corporation or the committee in preparing the plan and are instructing a valuer. Are they looking for a value of the property as if it was put together as one, or are they looking to the value of the property given the circumstances at the time that the valuer is instructed, where there is in fact a dissenting owner? In other words, is there going to be a discount to the market value because there is a dissenting owner?
Well, there's the point. There's the rub, Michael. The first thing they have to do is they have to provide an independent valuation of the details of the market value of the whole building at its highest and best value. Whether the highest and best value is on the assumption that the scheme goes ahead or the assumption that the scheme doesn't go ahead is a matter that's yet to be resolved. How a valuer can do that, whether he should make an assumption, or he or she should make an assumption that the dissenting lot owners will remain obdurate and the scheme will never be realised or not, is a matter that needs to be worked out. And a similar problem applies when the valuer is asked to work out the compensation value. Now the compensation value, that's the floor value beyond which the amount to be received by lot owners or dissenting owners, as the case may be, must not fall, is supposed to be based on the highest and best value of the lot, with various additions for expenses and so forth. The difficulty is, if, to take an example, the strata has been the subject of a rezoning, it would be unrealistic not to take into account the potential rezoning in determining the market value of each lot. How these conundrums are going to be resolved is a matter that's going to have to be explored by case law and authority, in my opinion. My inclination is that in determining the highest and best use to either a lot or a strata, one would take the best development one can possibly put on the site if it's obviously a redevelopment site. I'm not sure, however, that that was the intention of the legislation, particularly in relation to compensation value.
A couple of practical questions about timing. The property world likes to move, well, the development world likes to move reasonably quickly. How long do you think it's going to take for an average process to unfold through to completion?
I don't know the answer to that question, but I would have said at least 6 months to a year.
Mm.
What do you think?
I think hotly contested. It's at least a year. It might be 18 months, and that depends partially on hearing date allocations by the Land and Environment Court.
Yes.
And I think that presents a bit of a problem for the concept, because, as I said earlier, developers, in my experience, are not patient with their capital. This is quite an expensive process to put together. We talked about put and call options, so you can see a situation where a developer is going to put up some money to hold people to the table.
Yes.
And then there's the costs. Owners corporations aren't going to have reserves to throw at this, so they're going to be looking for entities to fund the process.
Well, I was going to say that, whereas it's nice to think of a strata community doing this all by itself, the funding required, the transactional cost will be large.
Yeah, I mean, with three parties, effectively an owner's corporation, a dissenting owner, and probably a developer sitting in the wings, funding development approvals and other things that go to adding value to property. It's easy to see costs being $1 million or in excess of $1 million.
And then there's the uncertainty to add to that. Just talking about the valuation process that the court has to be satisfied with. It seems to me to be a very challenging task for a court to determine the difference between the proceeds of sale of a lot, which may not be known at the time the application takes place at the court, and whether they'll be greater or less than the compensation value of the lot, which also may not be able to be established with absolute certainty.
Yeah.
So how the court can be satisfied that one unknown figure is necessarily higher than another figure beyond, on the balance of probabilities, is going to be a challenging task. And my point is that adds to the uncertainty of the outcome, at least at the moment.
I suppose from a commercial point of view, that would suggest to me that this process is going to be looked at and used and perhaps threatened in negotiations. Threatened's perhaps a strong word, but used as a card in negotiations in areas where property prices are very high because the land is quite unique. So we're probably talking about Sydney foreshore land, some absolute beachfront land perhaps on the Gold Coast. Bear in mind, of course, that the legislation is only applicable in New South Wales at the moment, but given that New South Wales has generally set the trend on strata laws, it's likely that others will follow. So I think it's going to be interesting to see the commerce intersect with the law on this.
Absolutely.
And it's going to be quite fascinating, because this is an area that is not going to, the commerce can't work without the legal process can't work without the commerce. It's going to require a lot of careful thought to navigate a deal through the process.
My concern is that the legislation will be amended, leading to more uncertainty. Rather like changing the rules of a game of rugby or something like that. What happens is that if you make hasty changes, it simply introduces more uncertainty. When the problems with the amendments have finally been resolved, they'll be amended again.
Yeah, look, I've become a little jaundiced about depending upon government for amendments to fixed processes. I think the market will be the driver of practical outcomes. This is new legislation. It's not going to be tinkered with or tampered with.
Well, I hope so.
Any time soon. So I think we've got some cases to run first, some lessons to learn. I'm particularly interested in what we can learn from overseas courts.
Yes.
There are, common law courts and common law countries, if I can call them that have been engaged in this area, and we can learn a lot from them. And I think, practitioners in this area are going to need to look outside the normal library of court decisions that they look at and look to other jurisdictions for guidance. And I think people that are putting these deals together the property professionals, the large real estate agents, the people that stand to earn considerable success fees if these deals can come off, also are going to have to be aware of what has happened in other markets, and I think that's going to be fascinating for us to take on board and learn about.
Can I just talk about a valuation issue which has come up? Some people talk about the slingshot effect. That is the phenomenon where the proceeds of sale in a collective sale have to be distributed in accordance with unit entitlement, and yet each unit must receive more than the compensation value. And this contains a difficulty or a nuance, because where for example, there are 3 or 4 or 5 nondescript units and a very plush penthouse on top, the compensation value of the penthouse will be a lot higher and will push up the proceeds of sale required to get the whole process through the courts. Have you come across this in practice?
I haven't, but I've seen some writing, some of yours, on the issue, and I think it's correct that this is a potential problem, and it may be that it stops a redevelopment occurring, which of course takes us back to the way units of entitlement were set.
Yes.
As long as 50 years ago.
Because if just one unit receives a share which is less than its compensation value, the whole scheme is doomed.
Can be doomed. So I think it's a case that this legislation is not going to fit all circumstances. Just as planning laws are going to put some constraints on redevelopment, I think the unit allocation is going to mean that some are going to be knocked out of the process right from the outset, where it's just not going to work. Because developers, whilst there might be a premium to be paid, they've still got to make these things work. The cost of the land has still got to bear a reasonable proportion to the profit.
Yes.
And so the economics, someone's going to have to run the economic ruler over things pretty quickly and say, well, look, this plan is thwarted by this unit allocation or not. That's going to have to be done very early in the piece to see whether or not the slingshot effect, as you call it, is ultimately going to rule a particular property out of contention for a redevelopment or a collective sale.
Yeah,
that doesn't stop, of course,
no.
then people going outside the process and agreeing to do it differently.
There's a final requirement that the court must be satisfied, which is that the scheme is just and equitable. A difficult concept to apply to this sort of arrangement, but I'll be interested in your thoughts on how it applies and how the valuation issues apply when there's a put and call option. How does the contractual right to call for the sale of lots at a certain price interact with a strata renewal plan which may specify a different price or doesn't specify the price which the purchaser will purchase the units?
Yeah.
And may that affect the justice and equitability or equity of the whole scheme?
As I read the legislation, the just and equitable provision is fairly attached to compensation issues, and I think it is going to be very hard to make these arrangements happen where there are deeds of put and call. I think the deeds of put and call are going to have to be very carefully structured so that firstly you get over the good faith hurdle, and secondly that there's a flexibility somewhere in the process to enable you to address the just and equitable issues that might arise. It's interesting, again, looking at Singapore, where it seems to me that the process of using a deed and put and call to hold people together whilst the process unfolds has not been followed.
No.
And I think what we've seen there, and certainly what is coming out of Canada, is that owners, groups of owners committees with or without backing, are driving the process and are calling for tenders. So in other words, agreeing that a property should be put up for sale, and then going to the market and finding the purchaser.
Oh, I see.
Now, that's
and who funds the process?
Exactly, and this is a question where, we need to look at the organisational behaviour of our strata schemes, and to see whether they're going to fund that process. Now, I've been acting for and against owners' corporations all my professional life, and I can tell you that getting them to buy a round of drinks after you win a case for them is tough.
I have experience of this.
So these people are not want to throw money around. So it's going to be interesting to see how that happens. If the deed of put and call arrangements are struck out because they conflict the process or they taint the process in some way, then owners are going to be left looking for other ways to proceed. But it's a question of somebody has to put up their hand first to say, I'm in this to I commit to selling my property. Are they committing to each other, or are they committing to a third party? I think is one of the areas that we will litigate, no doubt, in weeks and months and years ahead.
I look forward to that. Great pleasure, Michael.
I too will look forward to exercising some intellectual horsepower to that question. I don't know the answer at the moment, but I do know Australian strata schemes, and they are not going to put up the hundreds of thousands of dollars that are necessary to fund these cases. So some way is going to have to emerge for somebody to put up the capital that is required, and that comes at a price.
Can I move on to another issue arising from the just and equitable requirement, and that's what you might call the little old lady.
Or man.
Although ladies do tend to live a bit longer than men.
They do.
They still do. What concerns me is this, that there may well be people in the late autumn of their lives who do not want to move. They do not care about the money. They know that a sudden movement to another environment is not going to be good for them. But their relatives may take a different view. If there's a large amount of money on offer. It seems to me that in those circumstances, the professionals involved have to be very, very careful about taking instructions, and the court would have a significant part to play in determining the real views of dissenting owners in that circumstance.
Yes, I think that's right. Although before the dissenting owner is afforded that protection, they have to take a position. And I think for the vulnerable, it is going to be a big ask for somebody to sign an objection and to become potentially a party, or indeed they must become a party of some description to the proceedings. And I think that the protection of the dissenting owners, of course, was at the heart of the political issues and the difficulties in passing this legislation in the first place.
Yes, these are the people the legislation was designed to protect.
That's right. But so far, in the three cases that we've seen in the courts, and there's only three, so it's a very small sample size at the moment, the dissenting owner doesn't fit that description, as I understand the cases. And so we're yet to see, I think, the vulnerable person avail themselves of the process, but query how they are going to be given the strength and the guidance and the support necessary to take that stand. There might be a group, a community-based group, or a family that gets behind somebody to take a position. But look, the vulnerable are ultimately going to be bought out. I don't think we should forget that this is a legislative scheme which provides for owners to compulsorily acquire other people's property, and as long as the process is followed and the checks and balances are there in terms of valuation, the vulnerable, the dissentients, will ultimately be bought out.
It will be a difficult question, though. I would not be surprised to see in court proceedings medical evidence in circumstances like this being brought forward. That would be very, very difficult to measure that sort of evidence in monetary terms, despite the enthusiasm of relatives, I suspect.
Well, the other issue, of course, is we've got a whole other area of strata law about human rights and disability discrimination. So those areas could intersect. But there's no doubt at the moment that disability discrimination in strata schemes that are contemplating refurbishment and renewal for people as they age is another area of law that's evolving. So I think the point we've stumbled across here is a human element to this legal process and to this pursuit of great development profit. But there is this human element. And it's the human element that has been the focus of the politicians. It might turn out to be the focus of the courts as well.
The courts have to be cautious to make sure that the protection afforded to objectives who are pursuing exclusively commercial objectives will in some way reduce the protection available to people who just don't want to move for good reason.
It'll also be interesting to see over a much longer period of time how this plays out on the valuation of strata title property, because of this inherent possibility that it can be sold from under you, in the same way that company title is marked down as against strata title for different reasons. So that's something that someone should do a study on as well, to see whether the process by itself has any effect on market value.
By no means all stratas in New South Wales are residential stratas.
No.
And we get industrial stratas, commercial stratas, mixed industrial, residential and commercial stratas.
Exactly. Look at the service department industry, which has over 20 or 30 years been fueled by strata title leaseback schemes.
Yes.
Some of which have worked and many of which haven't. Interesting to see how it might apply there in schemes where something, and what's always concerned me about service departments is that they were put together to meet the criteria of the banks, not the criteria of the market. So the hotel user might want this, but the investor needs that in order to get the finance. So there's always been a mismatch there between perhaps what the community wants and what the financiers will deliver. This process might be used to tidy that up.
Well, I think there will also be significant issues in relation to the compensation value of industrial and particularly commercial stratas, where there's a premium on location and goodwill attached to it.
That's right. It's a different kettle of fish altogether. Less emotive, so I think some of those issues will be easier for people to deal with. Money fixes all things in commerce, or should, but I think the emotional elements of residential property is going to be difficult for a lot of consultants to deal with.
But the valuation issues will be perhaps more complicated in those circumstances, where you get a vast disparity in the compensation value from one unit to another.
That's right.
That will make the whole process most complicated for those wishing to go ahead with a scheme. We've been asked to address the key challenges that will have to be addressed. It seems to me that there are four, which we've to a large extent covered. First is going to be the cost and expense and complication of the procedure as a whole. Second is the extent to which powers of attorney and put and call options will assist the process, and I think we've already expressed some preliminary views upon that.
Yes.
Third, we're going to have to be guided by some authority, I think, in addressing the valuation issues. We'll do our best until we have some authority, but they're going to be complicated.
And some authority on the good faith arguments as well.
Lastly, there's going to have to, and this is more of a commercial issue, for not so much for me, but for lawyers who are putting together this deal, is going to be how costs are going to be controlled and how these processes are going to be financed.
I think on that point, there'll be a precedent that will develop in the same way that off-the-plan sales contracts developed over a period of time. I'm old enough to remember that process in the 80s and 90s. So there will be some precedents that develop. But I think what I would say to our viewers is that lawyers need to be approaching this topic with a high degree of commercial support from consultants and advisors. A legalistic approach is absolutely necessary to getting the process right, but an overtly legalistic approach will not see the deal done if that is indeed the object of the instructions. So I think one of the challenges for lawyers will be working collaboratively. As a profession, we're not particularly good at that. But this particular discipline, I think, this area that's emerging, is going to require different people with different expertise, and it might be that there is two lawyers on the job, one being a black letter backroom technocrat, and the other being quite a commercial operator who can work with people and massage things so that the legal framework meets the commercial drivers. So I think it'll be an interesting test for the profession to see whether they can step up to working collaboratively.
Potentially, one would have to be very careful about conflict of interest, particularly acting for the owner's corporation.
Well, that's
as
right.
opposed to the lot owner.
There's actually three sets of interests, aren't there, potentially? There's the
Yes.
lot owner, there's the owner's corporation, which is a separate legal entity and may comprise dissenting owners as well as supporting owners.
Yes.
And then there are the interests of the third party that we've identified that will probably exist to fund and drive the operation. Now, there are going to be times at which and I think in the couple of cases we've seen already,
Yes.
that the owners, as owners, are going to need separate representation from the owners as the owner's corporation.
Absolutely.
And separate again from the party that may be supporting the purchase. So there are very clear circumstances in which the parties' interests diverge at various parts of the process. And timing is one of them. An owner's corporation is going to have issues, or group of owners is going to have an issue about timing that might not be or won't be shared by a proponent of a grander plan who is there and can be quite take a long time to get to the process. So this is the mix. This is the challenge for lawyers, I think, is to say, well, how do we bind people to this process in a way which gives it enough time to evolve. It's an interesting space. It takes property law into the realms of joint venturing.
Well, it does, doesn't it?
Perhaps a collision of different worlds.
Although the developer is often funding the owner's corporation development, the developer's interest or the purchaser's interest is different to that of the owner's corporation. The developer or purchaser wants to maximise his profit, which enables reducing as far as possible the amount paid to the owner's corporation and the lot owners.
Yeah. So when an owner's corporation takes money from a developer to make this process happen, necessarily it comes at a price. So there's a conflict there, and an inalienable conflict, and that by itself might be enough to scuttle the process if a dissenting owner wants to take that point. So we come back to a point I made earlier, where I personally think that owners' corporations will somehow become the drivers of these processes.
Yes.
Because they will realise that selling their soul to the devil is not in their interest.
Yes.
And that they will do better by following the experiences we've seen overseas of taking this process themselves. That in itself is going to require people to stand up and put their money where their mouth is to fund the process. That's the challenge.
And if you read the Hansard reports when this legislation was introduced, that's really what what the minister and the government had in mind when they proposed this legislation.
Well, one of my colleagues in the College of Strata Title Lawyers is particularly keen to litigate on the question of the intent, that very point. Did the Parliament intend this to be a process that was used to fix buildings that were non-economic to otherwise repair, or was this a process that was to be used by developers to profit from repurposing strata title property? Victor Dominello's second reading speech would suggest that it was the former, not the latter. So that perhaps is another thing that we'll see emerge.